Okay, good morning, everybody. So we are towards the bottom of 51b, 5 lines from the bottom. Ton Rabbanan, Rabbi's taught. Ein makabling pikdonos lo min hanosh. You don't accept deposits, like if somebody um, wants to hire you to look after something, like a shomer. Lo min hanoshim, not from married women. Lo min havadim, or from slaves. Lo min hatinokos, or from small children. And the reason in all of these is that you're afraid that maybe it's not there. So mostly what a woman has belongs to her husband. Mostly what a slave has belongs to his master, and mostly what a small child has belongs to his father. So don't accept anything from them because you suspect that it's not theirs. Kibominesha, but if you do go ahead and do it, and you accept something from a woman, Yachzir Lisha, then who do you give it back to? Well, you might suspect that it doesn't belong to her, but she's the one that gave it to you, so you have to, you go give it back to her. Vimesa, now what if she dies? So Yachzir Labala, then you can safely assume that it belonged to her husband. Her husband had inherited whatever she had. Kibel Milavad, if you did go ahead and accept something from a slave, Yachzir Lavad. So again, you don't have any proof that doesn't belong to him. He gave it to you. You have to give it back to him. Be mace, but if he died while you still have the thing, Yachzir Larabo, then you can safely return it to his master. Kibel Minakatan. Here's going to be a little bit different. If you accept something from a child, Yasilo Sugula, don't give it back to the child, because we assume that the child is not able to manage his own affairs. So what should you do with this thing? You should set up a trust fund for him, something that will benefit the child. Don't give him the actual asset because he'll presumably fritter it away. Vimes, and if the child dies, Yachzir Yarshav, then you can give it back to his heirs. V'kulan, and in all of these cases, Sha'amr b'shas misas and shalploni
And
hain.
the child has heirs? How long? I mean, the child may be 6 years old. Until he has heirs, it could be 20 years.
Could be he could
So
have
where do you
brothers.
hold it?
He could have brothers or parents. I'm not sure who inherits from a child if he has his own property. But it's not just children, right? This person doesn't have children, then his brothers inherit.
Right. But we're talking here about a katan in this case.
Yeah. So Katan can have brothers who inherit him. I mean, look, the question is, does this child have his own funds? Now, it is possible for a child to have his own property, right? So that doesn't belong to the father. I can't offhand remember a particular, like, what if the child is an orphan, for example? Then he does have property rights, but we don't let him manage his own affairs, as we see here. Like, don't give it back to him, set up a trust. But the child who is an orphan can have brothers, and if the child dies, then they would inherit. Okay.
I don't know what the laws of Yorshim, of Yerusha are regarding a child.
Well,
Is it the
if you look
brothers,
in
the
the
parents? Is it okay, all right. I mean, I don't know.
yeah,
But if he
really,
doesn't have brothers,
okay, so he doesn't have brothers. I don't know. The Mishnah doesn't deal with that. If there's no Yarshim, then I don't know. Maybe you would look to the case of the rules for a ger, right? A ger who converts and doesn't have a family yet,
all
like
right.
doesn't have a wife or children, um, is his property, I believe, becomes hefker. But I don't think the Mishnah is really, the Brisa here is really dealing with that.
Yeah. All right.
Okay. Now, so V'kulan Shamar B'Shas Misasan Shel Plonihain. If each of these people, the woman, the slave, the child, are on their deathbed and they say, you know what, that picadon I gave to you doesn't really belong to me. It didn't really belong to me. It belonged to so and so. So we assume that their deathbed, they're doing their deathbed regrets and trying to put things right before they die. And so we accept that declaration that the thing belongs to the third party, and that's who you should return it to. Vim lav, but if you don't believe that it's sincere declaration, This is a kind of a strange thing, right? It's like we leave it up to the person who hears the deathbed confession, and we leave it up to him to decide if he thinks it's valid, it's true. So if you don't believe him, yes, perish leperushan. No, you can make your own declaration. Like you don't have to listen to what they say if you don't think that their declaration was correct, then you would still give it back to the husband, the master, or whatever. And here's a case. Dvesu de Rabba Bar
Will
Chana
they
Kikash.
themselves decide where it would go?
I'm sorry, who?
Is he saying that then the person who's holding it should decide where it should go? I mean, or the person
No, it seemed it probably means that you go back to the standard law, which is give it back to the husband or the master.
he didn't say to whom
Yeah,
it
it doesn't. It's not
belongs.
stated explicitly, but that seems to be the logical thing to do. Not that you can just give it to a random person. Like, where would that come from?
Mm, well, unless, yeah, I don't know. All right. I don't know.
Jesu de Rabba Bar Chana ki Kashachwa, the wife of Rabba, was dying. Amra, and she said on her deathbed, Hane kipe, these earrings that I'm wearing, de Marta ubne Barta. They belong to Marta and his grandchildren. They gave them to me to. It's not really mine. They gave them to me. Also coming to Rav, so he goes to Rav. Like, do I inherit these earrings, or do I have to give it to the person that she named on her deathbed? Amalei. So Rav said, Imahem nalach, if you believe her declaration. Now here it's even stranger because you have here Rav or Rabba is an interested party, right? So we're going to rely on his assessment of the claim, even though he's an interested party. That if he says, "Nah, she was just talking, nonsense. I don't believe what she was saying. Therefore, I get to inherit them." That seems kind of unfair. But anyway, so Rav said, "Imam Noach, if you believe what she said." Um, um,
I'll say
I'll say,
Kiverusha.
I'll say Kefirusha, do what she said. Vilo, but if you don't believe it, I say perush perusha. Then make your own. You can override that and keep them for yourself. Vikadam, right? Some say that that's not quite what he said. Hachim is what he said. I amidalach. If you estimate that Marta and his family, they were wealthy and it made sense that they owned a pair of expensive earrings, aseke perusha. So if there's objective evidence that this might be true, so there's a whole different thing, right? The first version is if subjectively you believe what she said, then act by it, and if not, then don't. And the second version is if objectively it seems like this is a reasonable claim, I say perusha, then do what she said below. But if not, I'll say perusha perusha. So this is also pretty strange because poor people can have valuable things that maybe they inherited or something, right? None of this seems to be very, very well based, but I think this whole area of case law is, dealing with kind of murky claims, and the rabbis attempt to deal with it. But I'm sure that you could find case law in which other factors were taken into considerations. For example, what I just said, sure, the person she named might be poor, but they had a rich great uncle who left them this pair of earrings or something. So, I don't know. See, there's a lot more depth here that the Gemara doesn't deal with.
He could claim that it was hers. If he didn't believe her, he said it's hers, and everything she owns is mine.
Right. Right. So then it seems like he's a pretty interested party there, right?
Yeah.
Yeah. So I don't know what to say about that. Now, next thing the Brisa says, I mean, a katan yasaskula. If you accepted something from a katan, you shouldn't have done it. You shouldn't have accepted it. But if you did, then when you return it, don't return it to him, but set up a trust. My school. What kind of trust? Rav Chisda Amar, Rav Chisda says Sefer Torah. You buy a Sefer Torah. The Torah has, the scroll itself has value. I think we're all aware that a Sefer Torah is a very expensive item. It's not going to lose value. And guess what? The child can study from it, right? He can use it for his education. Rabba Barafuna Amar, but Rabba says Dikla, buy a palm tree, Da'achamine Tamre. Never mind about the intangible value of education. We're talking about money here, right? A dollar is a dollar. You buy a solid investment that produces dividends. That for someone who can't manage his own affairs. Which is I don't know. I find that to be a very interesting dispute.
No, but with education, the person then can get a better job, and the job then supports him. So, but a palm tree can disintegrate tomorrow. The wind can blow it down, and he may have nothing out of that. It may be a poor investment.
True. Right. Although you're talking about what kind of job can you get by learning Torah tends to be, to teach Torah, right? But first of all, according to the Gemara, that's not really a job that you can get paid for. And although that is not our practice, there is workarounds for that. But yeah, look, any investment can go bad. Look, if you buy Sefer Torah and I don't know, no, it seems like a solid investment, but I don't think that you can really say that the dividends that it pays are financial ones. I think that's a stretch. So back to the Mishnah, we said that a father can't exercise a 3-year chazaka in his son's property, and vice versa. This applies even if, like, the son's grown up and he's not being supported by his father anymore. So even though they're independent of each other financially, still it's a father and son. There's still no chazaka. They would not. We would not assume that they would certainly protest against the other one using the land. Rava says Chol. Now, if they're independent of each other, financially independent of each other, then the Mishnah does not apply, and you can do a three-year chazaka. Amar V'Yirmi Midifte, Rav Yirmi said, Avda Rav Papa Uvda. Rav Papa took action in a case. Chalkula, he said there was a case where the father and son were independent of each other, and he said that the Mishnah's ruling doesn't apply. You can have a 3-year chazaka karava, like Rava said. Rav Nachman Bar Yitzchak. Rav Nachman said, "Ishtayli Rav Chia me Hurmi's Ardashir." Rav Chia from this place called Hurmi's Ardashir told me, "Tishtayli Rav Acha Bar Yaakov." Mishmei Rav Nachman Bar Yaakov, that he heard it from Rav Acha, he heard it from Rav Nachman. Holkulo, that the Mishnah's case does not apply when they're independent. And that is the halacha. The Mishnah is only talking about when one is financially dependent on the other. Tanya Nami Hachi, we have another brisa that agrees ben shechalak, a son who's emancipated from his father, and Ishta Shiniskarsha, or a wife that's now divorced, an ex-wife, they're like, they have the same chazaka rules as anybody else. The former relationship that they had that would obviate the use of chazaka is now gone, and they're like anybody else and can use the 3-year chazaka. Itmar, of a case, it was said, you have an estate, right? A father dies and he leaves several sons, and one of them is managing the estate. And by the way, as we'll see, this one is only a half brother. He is a son of a different mother than the other brothers. Okay, but he's the one that's managing it. You're looking through the papers of the estate, and you find deeds with the name of the managing brother on them. In other words, like it says, that let's say it's a loan document or title to something, and it's found among the father's papers, but it names the managing brother. V'amar Shlihem, and he says, yeah, my name's on it because it's mine, right? Shnaflu, where'd I get it? Shnaflu mi beis avi ima. Remember, I have a different mother than you, and I inherited it from my maternal grandfather. So this is not part of the estate of our father. This is separate funds that belong exclusively to me. Amarav, Olav Lahaviraya. He has to bring a proof, right? The assumption is the papers were found among the father's things. The assumption is that even though the son's name is on it, it really belonged to the father and is part of the estate, unless he can prove otherwise. Shmuel says, Alachin Lahaviraya. No, it's got his name on it. In order to the main assumption is, or the standing assumption is, that whoever's name is on the document owns the document. And if they want to prove out, if the brothers think it belongs to the estate, they have to bring some kind of proof. Amar Shmuel, and Shmuel said, Modali Abba, Abba, which means Rav. Rav's actual name was Abba. Rav was an honorary title. She'im Meis, that if that managing brother died, then he agrees that that the assumption will be that the now dead managing brother is the owner. So Maskif Papa, so Rav Papa said, Kulan Tanina Lihu Liasme Midi Lotain Lihu Avuan. How come the orphans, how come the estate of the dead brother, how come it has better rights than the brother himself, right? We don't do that. We don't generally say that some of them have a better the estate has a better claim than the assumption than the father.
Yeah, the
So
brothers, this fellow was his property, and so now don't his Yorshim have been prior?
well, that's the
Don't their
question.
rights
Is it his
supersede
property?
that of his brothers?
So that's the question. Is it his property? It has his name on it, but there's grounds to believe that it didn't belong to him. That's the whole dispute here, right?
And
Like
he
on one
inherited
hand,
it. He inherited it from
he
his grandfather,
claims that he inherited it.
from his grandfather,
Right,
his
but
mother's
the
side.
problem is that the papers were found among the papers of his father, the common father.
So if
So
the mother acquired it, doesn't everything that she owned belong? Wait, then everything she owned belonged to her
how do you
husband,
know that?
which
How do
was
you know
not
the
his
mother is
father.
alive? Maybe the mother's not alive. So when the grandfather died,
Right.
this was his the first relative that gets to inherit.
But this property was transferred from the grandfather to the mother, right? And the mother's
No, maybe
property
directly.
belonged,
Let's say it was transferred directly to the grandchild, to the
oh, because
grandson.
the mother wasn't alive.
Yeah,
Uh, oh, so this was outside the marriage then.
correct.
So the grandfather decided the mother had already died, so he was living with his father, let's say, or not living with,
Right,
doesn't matter. And so the
right,
grandfather had other property and he transferred it to his grandson directly.
right. Or he through a Yerusha or whatever. Yeah, but he
Yeah.
got it. That's right. He got it directly from his mother's family.
Uh-huh.
And,
Okay.
and so he's claiming that that his half brothers have nothing to do with this
Right.
property because they're not in that family. Okay. So Rav Papa says, well, wait a minute. Like, so the case we're discussing now is like, okay, so we have an argument about who has the primary rights to this property. But if the managing brother dies, apparently everyone admits that the heirs of the managing brother who died, they get the property, and we definitely say that. But why? Like, why would they have better rights than the guy himself if he were still alive? And to shore up that question, Varava apik zuga de sarbala v'sifra dagada tami yasme. Rava, in the case of orphans that inherited a tailor's scissors or a book of Agadata, which apparently are below Raya, without any proof, right? That these are metalzli, and there's not any document saying that, oh, I lent you these scissors or I lent you this book. B'dvarim ha'asuyim lahashil lahaskir. But these are things that are commonly borrowed, lent and borrowed. So Rava said, okay, somebody claims that they were his, then we're going to give it to them, right? So in other words, the Yisomim don't have any extra rights here, right? Just like if somebody came to claim the scissors from the person that they say they lent it to, and we would because it's something that's commonly lent or borrowed, we would say that that no, 1 second. We would say that he has to give it back. So why would you say for Yisomim? So for Yisomim, you would say that Rava said that give it back.
What are they saying with the agadata and the garments? They borrow and they give it back to whom?
So somebody who claims that he was the one that lent it to the guy.
Okay, so but what's the nafkamina here? This fellow, he had a star. He had the property with his name on it. So
Right. No,
how
we're
can you
just
compare this?
demonstrating. Good question. But we're demonstrating the principle that we don't advance a claim on behalf of orphans, on behalf of the estate, if that claim wouldn't hold water for the guy if he were still alive. Okay, so let's just finish this piece and then I'll explain a little further. Kiddush Rav Huna Baravin. Rav Huna sent this ruling. Dvarim hasin lahashil haskir, things that are commonly lent and borrowed, or rented. Ve'amar lekuchin hen biadi, and the guy who's holding them says, you know what? I didn't borrow them. I bought them. Ein oneman. He's not believed, right? So similarly, the Yisomim are not believed. So the principle here is that we don't advance claims on behalf of the Yisomim if that claim wouldn't hold water for the father himself. So where's this kasha? It's a good question.
But it's in this case, his name is stamped on the deed. So he has a claim in court.
Yes, that's right. But we're saying that his name is stamped on the deed, but the ruling we just saw was that, however, if he dies, then the Yisomim so there's an argument, right? If that helps, if his name is stamped on the deed, there's an argument whether we believe the name on the deed or we believe the fact that it was found among the father's papers, right? But there's no argument if in the case of Yisomim, if the managing partner dies and leaves everything to his children, right, then apparently everyone agrees that the Yisomim get to keep it, right? That we believe the evidence that his name is on the deed, and we don't take into account the fact that it was found among the father's papers. Right. Well, why would we advance that claim for the Yisomim? Why would we, why would anyone rule on behalf of the Yisomim when they wouldn't have ruled on behalf of the father if he were still alive under the same circumstances?
Yes, but have we made a ruling regarding the father yet? I mean, we found if he's still alive, he claims it's my property. Have we decided that?
So we haven't decided it, but we're challenging the statement that everyone agrees. Okay, so there's two sides here, right? One says believe the documents. One says believe the fact of the circumstantial evidence of where it was found.
Right.
But then we said that even the one that says believe the documents, in the case of where the managing partner died, and now the question is, does it belong to his estate or not? We would say no, believe the documents. So why would he change his mind?
That place if we hold that way, then the Yitomi would be entitled to it if we believe the document.
Right. So the question is, why make a different ruling if it's the Yisomim, if Yisomim are involved?
Right,
why would you rule on behalf of the Isomim when you wouldn't rule on behalf of the father?
right,
That's the question, right?
right.
And we back that up by saying, look, here's another case where the Isomim have the same deal as the father. We don't make allowances for the Isomim by giving them more benefit of the doubt. We don't do that. And so the answer, so the Gemara says, Kasha, yeah, it's a good question, right? So it's actually what you might say is what it's implying is that okay, so we actually would rule in accordance with the one who says that give it to the give it to the estate. Amar Rav Chisda. Rav Chisda says
That means give it to the Yatomim, right?
Yeah, Loshanu Eladein Cholukin Bisasa. When Rav said what Rav said, only this only applies where they're drawing where the estate that's being managed, okay, the brother that's managing the estate, he's paying everyone's expenses directly from the estate, okay. About chalukim bisasim, but if that's not the case, if everybody gets a stipend, like until the whole estate is settled, everybody gets $1,000 a month for to spend as they will on their sustenance. Amor me sasikimates. So then you could say, you know what? This brother is getting $1,000 a month. Maybe he's surviving on 500 a month, and he's been saving up money, and that's where he got the money to buy this property or make a loan to someone. And so the fact that that the papers have his name on it, and the fact that they're mixed up with the father's papers, is because he's already managing the estate, and he only has one lockbox for documents, and so there's reasonable basis to believe that it was his own money because he might have been saving it up. Okay. Now, Raya Mimai, when it says somebody's got to bring a
estate is
proof.
he managing? Is he managing the father's estate? Is he managing the grandfather's estate?
No, we're talking about the father's estate. The only question is the one that's shared, right, with his half brothers. There's no claim on his grandfather's estate. No one else. There's no one else involved. Let's assume he's the sole survivor. That's not what we're talking about. We're talking about the father's estate he shares with his half brothers.
But this estate, this property that he claims he has came from the grandfather, who was not related to these other brothers.
Right. So that's a little unclear to me. Like, why is this a better?
So that is not really the father's estate.
I think what it's saying is that even if there's no maternal grandfather who left him money, right, who might have left him money, even if that's not the case, there's still a way that we can assume that this managing brother has his own money, and that is if he's being given a stipend from the estate, and maybe he's living below his means and saving up money, and maybe that's where he got the money. So even if there's no grandfather, there's still a way where we could say there's still a situation where we could say that that it looks like it's his own money. It looks like it's and the document that names him is correct, even though it's found among the father's papers.
That document concerns land, right? Karka that is in his
could be a loan, could be title to a car. I don't know. Could be.
I thought we were
anything.
assuming this was land. This was Karka that he inherited.
No, I think it specifically mentioned the loan. I think.
Was it a loan? Okay.
Onos ushtaros yotzin al yado. So the onos is a bill of sale and a loan document. So it's not necessarily land. Could be anything. Okay. Amar Chisa. No, we just did that one. Raya b'mai. What does a raya mean? They have to bring a proof, right? What kind of proof can they bring that it belongs that the star is really in his name or really belongs to the father? Raya b'edim means witnesses. Raya b'kiyum star. It could be a court certification. Nachman. Rav Center of Nachman, Harav Hashmuel. You've got Rav and Shmuel. You've got Harabba Rav Sheshes, and you've got Rav and Rav Sheshes disagreeing over what kind of proof. Mar Kamas Firle, who do you agree with? Anonymous Nisiyadana. I don't know like who to rule like between these great people, but I know a brisa. And the brisa says, Tanya, Echad mina achin shaya nosin v'nosei b'toch habayis. The same case. One of the brothers is the managing the estate. And then there are documents that name this brother. And he says they're mine. Maybe he says I got them from my grandfather. All of Lahaviraya. He has to bring the proof. So that's the V'chein be'isha, and similarly, a woman who's a widow, he knows this from the sons of Tochabayis. She is managing the estate. But and there are documents that name her. And she says, that I got them from my paternal grandfather. Omi Beis Avi'ima, or my maternal grandfather. Olav Lavirai. Allah, sorry, Allah Lavirai. She has to bring the proof. My v'chein. What does that mean? Similarly, like how is this different than like why mention both cases? Because about the same, I might have thought Isha Kevin de Shavicha La Milsa. Since she's by being the executor of the estate, she is that's like her reputation, right? That's like it shows that she's trustworthy. So that's like a key. That's an asset to her, right? The trustworthiness that this position grants her. Because people say, "Oh, how nice it is that she's putting in the effort to look after the orphans." She's not going to be stealing from them because that would undermine her reputation. Like the best part about being an executor is you get this great reputation, and if she were to be caught stealing from it, then she'd be worse than nothing. So Kamash Malone, we don't say that. It tells us that now, even though she is a wonderful person and she's getting great reputation out of being the executor, nonetheless, if she still has to bring a proof if she claims if she has documents that name her.
So are we saying in this case the documents suggest that she inherited it, but
yeah, so it seems like the inheritance
woman
thing
inherit?
is like, look, if you can prove that there was an inheritance, that's one thing, right? But then that seems like conclusive evidence. But maybe she 1 second.
I'm
Like
just thinking when it
maybe
says v'chein ha'isha, we're trying to bring a similar case, woman versus before it was a man. So they're trying to, but does woman inherit in the same way that a man inherits?
there are ways where a woman can inherit. She's an independent woman now. She's not married, right? She's a widow, so she has her own property rights for sure.
Right. Benot lavchat, basically.
Exactly. Yeah. Okay, last thing in the Mishnah. Bamedvarim Amurim, the Mishnah says, b'machzik. We're talking about, so it named all these people who don't qualify for the 3-year chazaka. Avabenosin matana, but if it's somebody who gives a gift, achin shachoku, or brothers who are splitting an estate, etc., they can't do a chazaka. So Gemara says, Atu kolhani damrina and lavne chazaka ninu. Why? They can't do any kind of chazaka. It's taking the mission to mean that they can't do any kind of chazaka. But we know that they can do, the kind of chazaka where you do something constructive or destructive to the land in the presence of the owner. That itself is a chazaka. The 3-year chazaka is not the only kind of chazaka. So is the Mishnah implying that none of these shows? So I understand that the 3-year chazaka these people don't qualify for. But what about the kind of chazaka that is done, in the presence of the owner, and he doesn't protest? So isn't that a good chazaka for them? So Gemara says, yeah, you're right. You have to read that into the Mishnah. How do you read it? But when do these things apply? By chazaka she'eshi matana, when a chazaka that has where there's a claim, Kugon mocha amar lo macharti, like the seller says, I never sold it to you. And the buyer says, yes, I did buy it. So So that takes when there's a competing claim, that takes a 3-year chazaka. But if there's no competing claim, could go nosi matana. For example, somebody gives a gift, or brothers dividing the estate. A person who takes possession of abandoned property, basically a ger who dies with no heirs. Dilamikne ba'almahu, where the point of the chazaka is just to acquire the property. It's not to prove anything. Nalgadu paras kol shehu haricha chazaka. Then doing any kind of act is enough for a chazaka. If you're not trying to, so we're reading into the Mishnah that indeed, if it's just a chazaka that's intended to establish, a fact, but not against a competing claim, then those people do. That does work. And this is where Eli has recorded the next 2 days, and he's going to pick up from here in his recording. So we'll stop here, and we'll pick it up on Monday. Wish you all good Shabbos.
Same to you, Doug.
Shabbat
Same
shalom.
to you.